Welcome back, America. Hugh Hewitt from Studio West, where I used to broadcast all the time till I fled California. I went to Virginia because in California it's become ungovernable and expensive because of public employee unions, and I've told you that for years. Now comes a new book by really blockbuster author Philip Howard. If we ever get rid of or even somehow reduce the administrative state, it's going to be because of my guest, Philip Howard's book, The Death of Common Sense, and now this book, Not Accountable. How Rethinking the Constitutionality of Public Employee Unions. Philip, welcome back. Good to see you again.
Nice to see you, Hugh.
Congratulations. I'm going to get deep into the law with you rather quickly. So I want you to state the premise for people who don't teach constitutional law like me, or who are not bureaucrats, or who didn't used to run the OPM as I did, what the problem is. And then we're going to talk about the solution, which are constitutional proposals that I see some difficulties with, and I want you to walk me through them. But first, state the problem.
Okay, the problem is that when we granted collective bargaining rights to public employee unions back in the late 60s, people didn't anticipate how different it would be than trade unions. And almost immediately, the unions used this power, the requirement that any elected leader would have to satisfy them in order to work for government to run, to seize control of the operating machinery of government. And at this point, the main management tools, accountability, is non-existent, literally. It's like 0.02%. We're talking about, in one study, 18-year study, 2 out of 95,000 teachers in Illinois dismissed annually for performance, like zero. So there's no accountability, and there's no manageability. The rigid work rules mean that you can't reassign people, you can't take into account new circumstances, like there's a pandemic. Well, the contract doesn't say that anything about teaching during a pandemic or distance learning, so you have schools shut down for 2 years. And that happens on a daily basis in little ways. So nothing is broken that's fixed. You know, we have these schools around the country, like in Baltimore, 23 public schools have not one student proficient in math, and nobody can do anything about it. Nobody can go in and reassign the personnel. So the bottom line is that voters elect mayors and governors and other elected executives who no longer have the authority to run government. And
now I want to underscore that, Philip. My audience knows, the new ones won't. I left government in 1989 as the acting director of the United States Office of Personnel Management. After that, before that, I was the deputy director confirmed by the Senate and the General Counsel. And when I left, I said, anyone who's been in this organization knows you cannot win at the Merit Systems Protection Board. You cannot fire anybody. Don't try. Move them. Move them to a different hallway. They're forever. They're limpets attached to your ship. You'll never get rid of them. Since 1989, that problem has metastasized, and you lay it out in Not Accountable. By the way, the lunch rule is you've got to say not accountable 7 times for people to remember not accountable. I've also linked the book in my Amazon and my Twitter feed. Go and get it, pass it around. Now, to me, the problem is Congress has never used its reconciliation power to demand real reductions in the size of the federal workforce. Your argument is using the guarantee clause and the non-delegation doctrine, maybe the Supreme Court can save us. I want you to give a concise summary, then I'm going to put you through some paces because I'm skeptical. Gosh, I hope you're right, but I'm skeptical.
Okay, so the non-delegation doctrine is a very basic first principle of constitutional law, which is that an elected official cannot give their authority, can't sell it or give it to a private party. Once they've been elected by the voters for a period of years to the sacred trust of public responsibility, they have to keep it and make the hard choices. And what happened here is that the state legislatures, under pressure from these growing public unions and associations, wrote laws that basically delegated the governing powers, the power to decide who's a good worker, who's not, how to reassign resources in the workplace, all those things, how you manage government, they gave it to the unions. And so I think it's clearly unconstitutional. There's a provision in the Constitution called the Guarantee Clause, which codifies the non-delegation doctrine. And it provides that the United States shall guarantee to every state a Republican form of government. And what Madison said that means is that is that, remember, Republican form of government is, as opposed to a direct democracy, Republican form of government is that people elect someone for a fixed period of years, and they have the job of acting on their best judgment for the common good. And so now what happens is we elect people for a fixed period of years who have no authority to act on their best judgment.
Let me underscore that.
Yeah.
Yesterday, the EPA announced a new rule proposed. It's going into notice and comment rulemaking, which is pro forma. It doesn't really work. To raise the demands on the automobile industry so that 1/4 of all heavy trucks and 2/3 of all commercial cars must be electric vehicles in the United States by 2032. Congress did not pass that law. Congress has never reviewed anything remotely like that law. EPA has long had the authority to do tailpipe emissions, but this is a quantum leap forward, an aggressive assertion of economic power over the American people. It's a loss of liberty. And you argue, and I think persuasively, all of this is unconstitutional. But Philip, do you see any reason to believe that this Supreme Court, I know the Chief Justice, I know a couple of the justices, do you think they will take this case, revive the guarantee clause, and resurrect the non-delegation doctrine, which is dead right now?
Yeah, I think they will, and I think there's a good chance they will. If you read the recent Supreme Court opinions on public union power, they are clearly offended by what the effects have been on democracy. Remember, democracy is nothing but a process of accountability. So, voters elect somebody. If they do a lousy job, they elect someone else. If there's no accountability down the line, then democracy is just theater. You elect people to go.
I agree with you, and I love teaching Janice. I taught Janice last week, and I said this came close to being a success, and then Scalia died, and we had to do it all over again, and we finally won. But there was a plaintiff who had standing. The case was ripe. It hadn't been mooted, and they won. And I had Paul Clement on a couple of weeks ago, the former Solicitor General, trying to get the court to take a case that will put front and center the Chevron doctrine, which is another step. But it's just, we're not doing it fast enough, Philip Howard. It's killing the country.
Well, I agree. But, what's astonishing to me, because I just started looking into this a couple of years ago, is that everybody knows that the public unions are a terrible problem for government. I mean, not to put too fine a point on it, for regular public services like fixing, like transit systems or fixing potholes or trash collection, studies suggest that the rigid work rules mean that it costs taxpayers 2 to 3 times as much as it would cost in the private sector. So think of those dollars. I mean, overall in the United States, we spend over $2 trillion a year in public employee compensation. $2 trillion. So we're talking about 10, 12, 15% of the total GDP, and these people are not manageable. So even if you're a diehard liberal, how can you tolerate that amount of waste of resources that could be spent for, name it, any cause, including homelessness or anything else?
Yeah, Philip Howard, the book Not Accountable. I hope it is read by the justices. A few of them listen to the show every morning. I hope they get Not Accountable and give it to their clerks and say to them, can we get here? But first you need someone with standing to bring the challenge. And this is legal, this is high law. Who has standing to bring a constitutional challenge that's not a taxpayer?
So we're working right now on several lawsuits, including with a public interest law firm in Chicago. And depends on what the claim is. But in general, the most obvious standing is by an elected executive or an elected board. So it could be a mayor, governor, a school board, whatever. And the case is quite simple, which is that it's our constitutional responsibility to run this school system or run this town. And I can't do it because of these collective bargaining agreements.
That's
therefore,
they
should be invalid. Very simple.
You did not put that in Not Accountable. Because I read every page of this in 2 days saying, I got to talk to this guy. But I'm thinking like a con law professor, standing. You just gave me an articulated defensive standing. Who will bring the lawsuit? Which public interest firm is doing it? Is Common Good got lawyers?
Well, Common Good does have lawyers, but we're working with so we're already starting to work with the Liberty Justice Center in Chicago, which prosecuted the Janus case. We're talking with two other public interest law firms about doing lawsuits in New York and in Connecticut, and we're working on California.
And you need one in Texas so we can get the circuits to split. I'm really into this, Philip. I'm really into this.
Speaking of Texas, there was a Fifth Circuit concurring opinion in an in-bank decision a couple of weeks ago, quoting at length from Not Accountable. And the book.
Oh, really? Was Edith Jones the author?
It was Ho and Jones, Judges Ho and Jones.
You couldn't ask for a better panel. Did they use the Republican form of government? That's the guarantee clause for the benefit of the Steelers fans. Did that surface?
I don't think they were quoting that part of it, but they were quoting the book, and for as relevant to that case, which was not the guarantee clause. But there are steps forward, as I discussed in the book, for applying the guarantee clause, because it's never actually been applied by the court before.
No, it hasn't. They say it's a political question. I'm going to come to that in the second segment. But when you get up there, do you think you've got 6 votes or 5? I think the Chief Justice might be persuadable on this, because right now they can't avoid this anymore. If we want to preserve freedom, we have to curb the bureaucracy. We have to get rid of the public employee unions. We have to take their grips off the spending. They basically run California, Philip. Do you know that, right?
Yes, I do. I mean, it's really, and their political tactics are genuinely, and I go through stories of this, are genuinely brutal. If you're in a state like California, New Jersey, or one of the big union states, and you're a state legislator, and you happen to propose a modest reform to take back modest controls of the pensions or how government works, they will spend millions of dollars to kick you out of office.
Yeah, the California Teachers Association has a pipe in their hands, and they're going to hit your proverbial knees. Philip Howard is coming right back. The book is Not Accountable. Don't wait another day. Especially you lawyers out there, go out and buy it and have faith. It can be changed. Take some courage. Well, author Philip K. Howard, his new book, Not Accountable, is brilliant because it is readable. It's not going to overwhelm you with legal arguments, though they are all there. Philip, long ago and far away, I clerked on the D.C. Circuit. My judge, Roger Robb, was on a panel with Robert Bork and Harry Edwards. Case is called Hannock-Telleran. Judge Robb took one look at that case, and I'm not going to get into the facts. He said, political question doctrine, we're not touching this. The panel divided 3 ways, 3 separate opinions. Judge Robb, I had to live with the political question doctrine for 6 months. Turns out it's the killer blanket. It can suffocate any case if justices don't want to take it. And they normally don't take it when the power is committed by text of the Constitution to another branch or where there are no standards, a whole bunch of things. I think you've got Justice Thomas, Justice Alito, and Justice Gorsuch who would buy that the political question doctrine should not stop a consideration of the constitutionality of public employee unions. Where do you get your other vote for cert and your 2 other votes to win?
Well, as you said, we got Alito. I think Roberts is probably the least, is on the fence on something like this. But the other conservatives, I think, will go with us. I mean, Alito,
Brett Kavanaugh comes up the D.C. Circuit, and so did the Roberts. They know the administrative state, but I don't know. I mean, this would rock and roll the country, wouldn't it?
Yeah, in a good way.
In a very good way.
Yeah. Stuff would work again. And the reason I think this is not a political question is because for 2 reasons. One, it involves not a partisan issue, but simply a matter of structure. Who's in charge of firing a bad cop or a bad teacher? Is anyone in responsibility in charge? It doesn't matter what party you're in. Who has the authority to actually try to make the transit system work? Doesn't matter what party you're in. Whoever's elected needs that authority. So it's not it's not like gerrymandering. It's not like a partisan issue. How should we best draw the line?
Or foreign affairs. It's not foreign affairs, which is where really the political question comes up.
No, it's question. And the second point, which is why it's really vital for it not to be a political question, is that what happened here is that the legislatures, under influence from the unions, took away the power of the executive. So it's not that the legislators did it to themselves, although they did, but they took it away from the branch of government that's supposed to operate daily operations. And so, so in federal law, and I think the unconstitutionality of parts of the Civil Service Reform Act of 1978 that mandate collective bargaining and that have all these detailed provisions on discipline, which result in zero discipline.
Merit Systems Protection Board, abandon hope, all ye who enter there. Yep, yeah, terrible.
99% of all federal employees get a fully successful rating. Why is that? Because if you say one negative thing, you have to go to a trial before some arbitrators, and the arbitrators are approved by the unions. like the whole thing is crazy, right? So,
Philip, your public service here is, again, like with death of common sense. How do we fix the problem? And we need the court to step in to restore constitutional government. That's your bottom line. By the way, kudos on starting with Derek Chauvin. The cop who killed George Floyd should not have been on that police force, but it was impossible to remove him because of the police union.
Or even to reassign him. And in the prior decade, the Minneapolis Police Department, it's not like Minneapolis is like some horrible, regressive, deep South town. It's Minneapolis, for God's sake, right? They had 2,600 complaints for inappropriate police behavior. 12 resulted in discipline, 12, of which the most severe discipline was a 40-hour suspension. So we're talking about union rules that preclude any accountability. Well, how the hell can you run a place? And by the way, the problem with not accountability is not just that there are bad actors like Derek Chauvin. The problem with no accountability is it corrodes the culture of the entire
Oh my God,
life.
Randy Weingarten is out there campaigning against educational reform because it's in the interest of her members to keep everyone trapped in failed public schools. It is public choice theory on display. And you have done a fine job stripping the bark off of this, but you got to go faster, Philip. I mean, you really do. We are running out of runway.
Well, first of all, I agree with that. I spent 2 hours on the phone yesterday with public interest law firms about possible lawsuits. I spent all morning with some of the leading constitutional scholars, in the country, Akil Amar, Philip Bobbitt, people like that, discussing all these issues, because ultimately what I'm finding is that even liberals, when they're forced to look at the facts here, see that there's a problem. So you're talking about...
It's not stage 4. It's stage 5 cancer. And it's got to be cut out, and you got to throw everything at it, and Not Accountable does that. That's Philip Howard's brand new book, Not Accountable. Can't recommend it highly enough. When you get your law firm, tell me, we'll raise money for it. I'm all in, Philip. Good luck. We need a Hail Mary, and sometimes Ahmad Rashad catches the ball. Philip Howard, thank you. Good to see you again.